Okay, we're live. Ay, kamay lang, hinilang. Okay, I think this is good enough. Is it? Yeah. Welcome guys to my live stream. I'm live streaming because I feel very sleepy and I think nalipasan ako og tuka, and I hope that my brain will still work in the morning. Nakayalo sa kumpun. Yeah, right now I'm trying to memorize ICJ Statute, Article 38, Paragraph 1, and we're going to be talking about sources of international law, and then also the Restatement of U.S. Foreign Relations Law, Section 102. So we are required to memorize this, and we don't know who's going to be reciting these memory verses, verse. So now I'm going to try to memorize. I did already try to memorize all of it, but I think I'm being counterproductive, but I'm also I really need to cover everything. We really don't know who's gonna be reciting. I feel like I'm gonna be called because I wasn't called last week. Was I? I don't think I was. Okay. So let's start. Oh wait, I need to send the link, this live streaming link, to someone important to me. How do I send the link? Oh no. YouTube. My library. Ay, nako. It's already 3:07. I hope to finish by 3:30. I really wanna sleep. I've had this bad habit of not sleeping, trying to cover everything. Napakoy digest. I still have one digest that I haven't properly fixed, and I need to get that fixed before class because maybe I should do that now and then just study later. I don't know. Okay, so my messenger app is glitching. Okay, let's start because we don't have any much time left to waste. ICJ Statute, Article 38(1). This court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a. International conventions whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom as evidence of a general practice accepted as law. C. The general principles accepted, recognized by civilized nations. D. Subject to the provisions of Article 59, whatever that is, judicial decisions and the teachings of the most highly qualified publicists of various states as subsidiary means for the determination of rules of law. I got it. International customary principles of law. I forgot that phrase, of law. Well, anyway, that was good enough. Okay, next, let's try to Memorize. Wait. Try to memorize the Restatement of U.S. Foreign Relations Law, Section 102. 1. A rule of international law is one that is accepted as such by the international community of states, A, in the form of international customary law. The form of customary law. Wait a minute. Form of customary law, of course. It gets confusing because this part it says customary law, and then the next says customary international law, and then the third one it says customary international law, and then in the fourth one it says customary law. So like, what on earth are you trying to do? Are you trying to confuse people by using inconsistent phrases? But whatever. Okay, let's do it again. What's it called? Restatement of U.S. Foreign Relations Law, Section 102. 1. A rule of international law is one that is accepted as such by the international community of states, A, in the form of customary law, B, by international agreements, C, or C, by derivation from general principles common to majority of legal systems of the world. Common to the major legal systems of the world. Oh. Let's do that again. Oh, this is so tough. Restatement of U.S. Foreign Relations Law, Section 102. A rule of international law is one that is accepted as such by the international community of states, A, in the form of customary law, B, by international agreements, or C, by derivation from general principles common to the major legal systems of the world. Is it common to? Yeah, that's major systems of the world. Very relaxing. Kind of want to drift away. 2. Customary international law results from a general and consistent practice of states, followed by them from a sense of legal obligation. From a sense, right? Yeah. I got it. 3. International agreements create laws for the states, parties thereto, and may lead to the creation of customary international law when such agreements are intended for adherence by states generally and are in fact widely accepted. Get that right? Well, for the states, parties that do not lead to the creation of customary such agreements intended for adherence by states generally. I got it. Lastly, 4. General principles common to the major legal systems, even if not incorporated or reflected in customary law, may be invoked as supplementary rules. Oh my gosh, I forgot. I was almost there. I didn't trust my gut. May be invoked as supplementary rules of international law where appropriate. Oh my gosh, I was that close. Okay, let's go over from the top. ICJ up until the restatement till the very end. Okay, let's do it. ICJ Statute Article 38, Paragraph 1. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a. International conventions, whether general or particular, establishing rules expressly recognized by the contending states. B. International custom as evidence of a general practice accepted as law. C. The general principles of law recognized by civilized nations. D. Subject to the provisions of Article 59, judicial decisions and the teachings of being most highly qualified publicists of various states as subsidiary means for the determination of rules of law. Restatement of U.S. Foreign Relations Law, Section 102. 1. A rule of international law is one that is accepted as such by the international community of states, A. in the form of customary law, B. by international agreements, or C. by derivation from general principles common to the major legal systems of the world. 2. Customary international law results from a general and consistent practice of states followed by them from a sense of legal obligation. 3. International agreements create laws for the states parties thereto and may lead to the creation of customary international law when such agreements are intended for adherence by states generally and are in fact widely accepted. 4. General principles common to the legal systems, even if not incorporated or reflected in customary law, may be invoked as may be invoked as supplementary rules of international law where appropriate. I did it. That took a long time. That was like 4 minutes, almost 5 minutes. Wow, I did it. As to whether I'll be able to pull it off later, I'm not sure, but I'll do my best. Thank you for being with me, guys. But I don't think I'll stop now. I think I want to continue studying a little bit. I just want to cover all of what's in the coverage. Oh, oops. Let's remove all those. And you know what's surprising me right now? I haven't had any episodes of spacing out or my absence usually. Oh my gosh, anyway, that's the least of my problems now. I'll have that addressed by the dentist soon. Anyway, wait. Makita akong stuff. It's embarrassing. I thought monitor screen is fast. Laptop screen. Yeah. Wait a minute. This thing in the bottom. And let's study together. What are we gonna study today? Yeah. Okay. So in the coverage we have I totally messed up. I forgot to assign one case, and I'm really thankful to one of my blockmates. He basically saves our asses all the time. He's probably the haligi ng tahanan of our block. Okay. Hard law versus soft law, formal sources, ways of grading. I wonder if he's going to ask us what a hard law is and what a soft law is, but I feel like. Formal sources, ways of grading a rule. Yeah, I've already studied this one. I think this is what we were trying to memorize. This is how international law is created. If you need a reference, you just cite ICJ Statute Article 38(1). That's how international law is created. And ways of classifying legal rules. By their content, civil law, political law, manner of their creation. Yeah. International rules classified by their formal source. Okay, so this is gets the way we classify rules for legal rules. We usually go according to content or by their manner of creation. But as for international rules, they are classified by their formal source. As for unwritten custom and international law, how are they created? Well, they're created by states through general consistent practice performed with consistent practice of states generally and are in fact widely accepted. So, in fact widely accepted means opinio juris. I think the full term here is opinio juris something necessity. So the ILC draft conclusions on identification of customary international law, we will look at that. Draft conclusions on identification. Identification of customary scope, present draft conclusions. concerning the way in which the existence of the laws of custom to be determined. To determine the existence and content of a law, examples are just there is general practice that is accepted as law. Opinion duties. General practice accepted as law. So there's a scope, and then there's approach. There are two elements. General practice accepted as law. And assessment of evidence by the two constituent elements. Whether there is a general practice and whether that practice accepted as law, regard must be had to the overall context. So dapat context, but also two constituents to be separate and certain. This requires an assessment of evidence for each element. Okay, so you have to check if it's generally practiced and if it's accepted. General practice. You know what? This is crazy. Why am I studying so hard for this subject? I mean, I'm studying stuff that I should be learning in class. Well, anyway, I think that's law school for you. You have to come to class prepared as if you already know everything, but you just confirm your knowledge in there, just correct whatever misunderstandings you have. I think that's how law school really works. I'm kind of tired of it now because there's only 4 of us in class. Constantly being grilled or on deck. It's kind of tiring. Requirement of practice. The requirement of general practice of as a constituent element of personal to the practice of states when it comes to the formation, expression of rules. I think we should have digested this one. My bad. Requirement of a general practice as a constituent element of personal expression to the practice of states contributes to the formation, expression of rules, practice of international rules, to contribute to the formation. Conduct. I'm so sleepy. Forms of practice. Practice may take a wide range of forms, physical and verbal, in action. Forms of the same include but are not limited to diplomatic acts, correspondences, leadership, international and internal conduct in connection with treaties, executive conduct, including. Okay? There is no predetermined hierarchy among the various forms of practice. Assessing a state's practice. Account is to be taken of all available practice of a particular state, which is to be assessed as a whole. Must be general. Relevant practice must be general. Yo, we really should have digested this, but it doesn't matter. It's done. We'll just read as we go through this. We'll familiarize ourselves. Maybe Sir Raj has a mnemonic ready with him or whatever. Accepted as law, opinion juries. Sense of legal right or obligation, general practice and acceptance, from mere usage or habit. It has to be accepted as law. Like, you have to do this because, this is the right thing to do. If you do otherwise, that's against, something, against norms or something. Forms of evidence as acceptance of law. Public statements, occasions from my correspondence. Okay, so we have to remember how we do this, because why this is important? Because this is how you are going to prove that a certain law or a certain certain customary law actually exists. Because if you're going to try to invoke customary law, in court for some whatever cause you have in court, you're gonna have to prove it that that customary law exists indeed, and you're gonna have to show, yeah, that it is accepted as law in what the international community. I mean, in countries. Significance of certain terms for identification of customer identity. Rules set forth in a treaty may reflect the rule of customary identity if it is established in the treaty. Okay, so here's the tricky part, because you're gonna have to determine which came first, you know? Is it the treaty or is it the customary law, international customary law? Oh no, customary international law. Because a treaty or an international agreement can actually lead to the creation of a customary international law. You know, so you have to be careful. Where is the source, or where's the source actually? And on the other hand, a treaty is also sometimes, it can also be the source of certain practice. Wait, I got that other way around. A treaty can also be the result, although the restatement of the U.S. Foreign Relations Law doesn't say that, but all you really have to know or determine to know what the source is. Wait, what was I saying before? If it's a treaty to a custom, it is when if it has been intended for adherence by states generally, and is in fact widely accepted. You know? So this led to the crystallization of a real customary intention that had started to emerge prior to the conclusion of the treaty. It codified a customary international law, and it crystallized that rule of customary. Okay, I get this. You know why this is important? Because customary international law is binding for states, you know, and treaty is actually, it cannot be binding to a state if they're not signatories of that, you know, treaty. But then again, you know, that's why you really have to determine where is the source, because if it's a customary international law, you can invoke that, and that certain entity or state that you're trying to sue will have to abide by that because it's binding. Resolution in international organization. Yeah. Resolution adopted by provide evidence for determining the existence of content of a rule of customary. Bro, this is a pretty long sentence, and I don't think it was that well written. I don't know, because I didn't understand a thing. A provision in a resolution adopted by an international organization that the rule of customary is practice. That is okay. So that's really the, like, at the end of the day, the most important part is really a general practice that is accepted as law. If you don't have those two elements, then you don't have a customary international law. Of course, internationals in existence because subsidiary means for determination. So it's only subsidiary, okay. The board may be had as proven oh my gosh, I'm so scared I might not be able to wake up. This is a cute. This background music is pretty cute. What is it? What's the title? Bro, I have like the attention span of maybe a studious goldfish. Where state has objected to a rule of customary international law while that rule is in the president. The rule is not opposable to the state concerned. Not opposable to the state. What does this mean? The rule is not opposable to the state. It's not opposable to the... I don't even know what this means. Well, I'm not gonna spend a few seconds to look it up. I'm just gonna move on to the next. Objection must be clearly expressed, meaning to that sentence. The present draft conclusion is without prejudice to any question concerning preemptory norms. Oh my gosh, here it is again. Preemptory norms of general international law. I don't understand what's use cogents. Cogents. Oh gosh. A category of norms that govern customary international compelling law. Preemptory. Wait, I thought it was international customary international law that's mandatory or something. I'm now very confused. Which no derogation is permitted. Oh my gosh, it's kicking in. I'm really getting sleepy. Okay na yan, I'm not gonna read that now. I'm the only one awake! Boo boo boo! Okay, so... where were we? We're gonna try to... And then this case is important because we see it being applied. You know, use cogents because they use this as their argument to say that there's an obligation to... Well, let me just recall. I think it is to insist that there's an obligation to apologize or something. I totally forgot. I think, yeah, compelling law, they used it as an argument. They used it as an argument to claim that the comfort women system was a crime against humanity, sexual slavery, and that these international crimes, or rather the prohibition against these international crimes, is jus cogens, and there's no derogation possible. So meaning they try to argue that we must not, we cannot ignore these violations against the rights, against human rights, you know, and so we are duty bound to set these things right, and by waiving the claims of those comfort women, it's like the government has broke its duty or obligation, or it breached its obligation to punish certain crimes against humanity. So that was their main argument. And what did the Supreme Court say about this? Scoggins. Aside from the points, well, for one, the Supreme Court emphasized the discretion that lies with the executive department in forming our foreign policy, and that it is political already when it comes to questions of relating to foreign relations, and that is something beyond the ambit of the Supreme Court's power. Then second, the Supreme Court also talked about how certain international settlements were done by states, and in this case, the Allied powers back then, fighting against the Axis powers. They made these international settlements in order to finally achieve peace, but of course a price had to be paid. Such international settlements would already remove or wipe out the chance of individual claimants to pursue their cases against their cases from nationals of the other countries like Japan, and that is just the price that would have to be paid. Anyway, in this case, the Supreme Court emphasized or made it clear that the Philippines is not under any international obligation to espouse the petitioner's claims. So, Scoggins? Was it Scoggins? Scoggins. Obligation for everyone. This is important because I don't think I'm gonna read the full text anymore. I'm really sorry. Should I? Okay, fine. Gosh, what? Okay, let's just skim through this. Mhm. Rape of Nanking. Shucks, grabe uy. Gosh, soldiers were so beastly. Hmm? To try to, like, this is kind of like a lesser evil. Grabe hoy. They went on a rampage. They could have at least, like, have done something less evil, like make it like incentivized or something. I mean, I see a lot of that today. People just willingly giving themselves for incentives. So, wait, what am I talking about? Hmm. My, oh my gosh. Why do they hurt the women? They just wanna really have like a punching bag or something. They should have given the man like punching bags with holes or something. Oo yan, may ostracize pagid sa family. But it is kind of confusing. Um, they went on appeal and they were granted the petition. Then they went up again a second time. They were denied. Like it's kind of weird. Parang paasa. Hirohito. I'm really sleepy now. Oh. Oh, I'm very sleepy. Oh my gosh, katugon na. Okay, I think I need to end the stream now. Good
Okay,
night.
so public international law.
Bye.